Thanks so much to Dr. Spalding for organizing this event. I am delighted to be with you this evening. I am a big fan of Hillsdale College. I've interacted with Hillsdale faculty and students and alumni in both social and academic contexts, and I am very impressed with the education that Hillsdale has on offer. So I'm particularly delighted to be with you here tonight. I'm going to talk this evening about the obligations of duty in the face of private preferences and the obligation of duty in the face of intense public pressure to the contrary. And I'm going to begin with a story from the Revolutionary War era. John Adams' representation of the British soldiers who had been involved in the Boston Massacre. The Boston Massacre happened in 1770. At that point, tensions between the British colonists, I'm going to move this microphone over, British colonists and the Crown were rising. So tensions were high, and British soldiers were stationed in Boston, and there was no love lost between the British soldiers and the Bostonians. The Boston Massacre became, and those of you who have been to Boston and done the Freedom Trail have seen the site of this, the Bostonians were taunting the soldiers who were stationed there. And what began in taunts then turned into a crowd of 300 to 400 people, erupted into more taunting and violence, and it ended when the British soldiers shot into the crowd, killing 5 people. The soldiers were charged with murder, and there was little public sympathy for them, to say the least. There was a lot of public pressure for them to simply be lynched. They couldn't find counsel to represent them. And then John Adams stepped up. Now, obviously, John Adams was a patriot, so he couldn't have felt a lot of personal sympathy for the British soldiers. His sympathies were not allied with theirs. But he believed that it was vital that the British soldiers received a fair trial. He believed that the American cause for self-government would be harmed if Boston justice was not truly just, and so he agreed to represent the soldiers. Yet he was reviled by many Bostonians for doing so. He faced intense public pressure about that decision, about his choice to represent the enemy. Now here's what Adams himself had to say about it. I had devoted myself to endless labor and anxiety, if not to infamy and to death, and that for nothing except what was and ought to be all in all a sense of duty. John Adams put aside personal preferences, he stood up to public pressure, and he did his duty. And moreover, he did it to the best of his ability. He didn't do his grudging, minimal best. He did his absolute best, and the captain was acquitted, and most of the soldiers were, and those who were not escaped the death penalty. Now, John Adams did these things as a lawyer, but adhering to duty in the face of a contrary personal or political preference and in the face of public pressure to the contrary has particular resonance for the job of a judge. A judge is obligated to apply the law as it is and not as she wishes it would be. She is obliged to follow the law even when her personal preferences cut the other way, or when she will experience great public criticism for doing so. I'm going to talk about this with a focus on the Supreme Court because those are the cases with which you will be the most familiar and the judges who you'll be familiar with. We have been fortunate in our history to have justices who have been willing to do their duty, even when it may run against their personal sympathies and even when it will subject them to public criticism. I'm going to give you an example from a famous dissent, the dissent of Justice Robert Jackson in the case of Korematsu versus the United States. That case challenged the constitutionality of the order commanding the exclusion of the Japanese from certain areas during World War II. The imposition of curfews, exclusions, and ultimately the Japanese internment is a stain on American history. As a congressional commission later described it, the internment was motivated by racial prejudice, war hysteria, and a failure of political leadership. But the widespread public support for the Japanese internment is reflected in the fact that Earl Warren, who was then governor of California and later became our Chief Justice, who led the court when Brown versus the Board of Education was decided, supported the Japanese internment. It was a time of war and people were carried away. Now, the internment of the Japanese derived its authority from an executive order that had been signed by Franklin Delano Roosevelt. Robert Jackson owed his career to Roosevelt. Roosevelt had appointed him to the 3 jobs that are the most prestigious that any lawyer can have. Robert Jackson appointed him to be the Solicitor General of the United States, the Attorney General of the United States, and he appointed him to his seat on the Supreme Court. And in addition to their professional relationship, they were friends, longtime friends. They were both from New York. Yet Jackson did not allow whatever personal loyalty or affection that he had for Roosevelt influence his decision in that case. Unfortunately, he was in the minority. His was a dissent. The court decided 6-3 that the exclusion order was constitutional. But Jackson wrote a vehement dissent objecting to the constitutionality of an order that rounded up people, many of them, most of them, American citizens, simply because they were of Japanese descent. He argued that that could not be justified as an exercise of military power. There had been no suspension of habeas corpus, and that is the provision in the Constitution that permits the exercise of that kind of emergency power. Duty, not politics. Being a judge takes courage, the courage of Robert Jackson. You are not there to decide cases as you may prefer. You are not there to decide cases as the public or as the press may want you to. You're not there to win a popularity contest. You are there to do your duty and to follow the law wherever it may take you. Justice Scalia used to say that a judge who likes every result that she reaches is not a very good judge. In fact, she's a very bad judge. The law simply does not align with a judge's political preference or personal preference in every case. And so it will be the case that judges have to make hard decisions and that they have to decide cases in ways that yield outcomes that are not the outcomes they would prefer. I've been at this only for about 1.5 years, and I can attest that that has happened to me many times already. But that is the duty of a judge, to decide cases in the way that the law requires them to be decided, and not simply, from the hip, if I'm saying, what would Amy Barrett like to see the result in this case be? If the judge is willing not to apply the law, but to decide cases in accordance with personal preference rather than the law, then she's not actually functioning as a judge at all. She's functioning as a policymaker. The fact that every judge wears a nondescript black robe, I think, is a powerful testament to this fact. It symbolizes the impersonality of the law and the dedication that each judge should have to the rule of law. The black robe was not the custom of the nation at its beginning. At the start, judges, including federal judges, including the first justices of the Supreme Court, wore colored robes. They would wear red robes trimmed in ermine in the custom of British judges, or some of them wore robes that were in the colors of the academic institution from which they had graduated. So much like academics when they wear regalia at commencement, that was the custom of judges at the time. But John Marshall, who was not our first Chief Justice, but was the foundational and probably the greatest of Chief Justices, is the one who changed that tradition. At John Marshall's investiture, he showed up wearing a simple black robe. And soon thereafter, his brethren, the other members of the court, followed suit. And today, all federal judges wear a simple black robe in deciding cases when they sit. So why do I think that's important? Why do I think that reflects the symbol of the impersonality of the law? Because the focus should not be who is deciding the case. The focus shouldn't be on the judge. The judge shouldn't be drawing attention to herself or himself. The focus should be on the law. The judge should be deciding the case not in accordance with her individual preferences. So the black robe doesn't express individuality. And a judge should not be deciding cases in accordance with her individual preferences. The black robe symbolizes that all judges share a dedication to the rule of law, that we are engaged in a common enterprise of applying the law and doing our best job at it. Justice should not turn on what judge you get. It should turn on what the law requires. Now, you might be saying to yourselves, well, that's all and good, but judges are human. Human beings have preferences. Human beings have commitments. And how could human beings ever separate out what their personal preferences are from what the law requires? I insist that that is possible. It is something that every judge must be vigilant about, but it is impossible. That is the nature of the job, and that is the judicial duty. I'm going to share with you a couple of my own techniques that I use to try to guard against any sort of bias. When I write an opinion, I try to view it through the eyes of the party that I'm ruling against, through the losing party. So I try to imagine that it is me or someone I love. Let's imagine it's a criminal case, that it's one of my own children who's on the other side. To try to check and make sure, am I deciding this case in the most honest way and not out of any personal bias or personal sympathy? If this was someone who I loved who was on the line, could I honestly say that this reasoning, obviously I would want to decide the case in favor of my child, right? But could I honestly say that this reasoning is one that I would apply to someone that I loved dearly? And I do the same thing for colleagues that might disagree with me. So the job of judges is to sift through arguments. Sometimes the arguments in a case, especially at the Court of Appeals level, will be pretty one-sided, and there'll be pretty easy agreement among the three-judge panel about what the law requires. But the cases are sometimes closer, and there will be good arguments on either side, and it's the job of the judge to decide which of the arguments is better. And as I draft an opinion in that kind of case, I do it with an eye towards what colleagues who are likely to disagree with me, what would the dissent think? Do my arguments hold up? Have I really given due weight to everything on the other side? What will the dissent say about this? And if I write the opinion that way, I am really giving the arguments on the other side their full due. Because when a judge has tunnel vision, when a judge makes a knee-jerk decision about how a case should be decided based on how the judge wants to see it decided, then the judge has a hard time guarding against that risk of personal preferences creeping in. It's only when the judge disciplines herself to really consider the best legal arguments on both sides of a question that the judge can do her best job at trying to make sure she is adhering to that duty of following the law wherever the law may lead. Our foundational constitutional commitment is to the rule of law. And for more than 2 centuries, the federal judiciary has worked assiduously, if not always successfully, has worked very hard and mostly successfully to develop and uphold the rule of law. We have an amazing Constitution and we have an amazing judicial system. We should be proud of it and we want it to continue. For my own part, I became a judge to contribute to that tradition, and I would have had no interest in the job if the job was about policy making and about making policy decisions. My interest is in contributing to our tradition of judges upholding the rule of law. And there's a lot of talk these days about the courts being mere political institutions. But if we reduce the courts to mere politics, then why do we need them? We already have politicians. Courts are not arenas for politics. Courts are places where judges discharge the duty to uphold the rule of law. I'm going to stop there and then invite my student Stephanie to come up, and we'll just have a little bit of back and forth.
So to start, I'd like to talk with you about the confirmation process.
Okay.
It wasn't that long ago that you went through it. And there was a lot of media discussion about whether the faith of a judicial nominee is relevant in the confirmation process. You yourself got quite a bit of attention on that question. So what role, if any, should faith of a nominee have in the confirmation process?
None.
Say more, that's not enough.
Yeah, I wouldn't have let you get away with a one-word answer. None. I mean, we have a long tradition of religious tolerance in this country, and in fact, the religious test clause in the Constitution makes it unconstitutional to impose a religious test on anyone who holds public office. So whether someone is, Catholic or Jewish or evangelical or Muslim or has no faith at all is irrelevant to the job, and in fact, it's unconstitutional to consider it as a qualification for office. I think there's been a lot of public debate about that, so I don't think I have much more to add. I think that's just clear. I do have one thing that I want to add to that, though. I think when you step back and you think about the debate about whether someone's religion has any bearing on their fitness for office, it seems to me that the premise of the question is that people of faith would have a uniquely difficult time separating out their moral commitments from their obligation to apply the law. And I think people of faith should reject that premise. All people, of course, or we hope, most people, right, have deeply held moral convictions, whether or not they come from faith. People who have no faith, people who are not religious, have deeply held moral convictions. And it's just as important for those people to be sure, I just spent time talking about the job of a judge being to set aside moral convictions, personal moral convictions, and personal preferences and follow the law. That's a challenge for those of faith and for those who have no faith. So I think the public should be absolutely concerned about whether a nominee for judicial office will be willing and able to set aside personal preferences, be they moral, be they political, whatever convictions they are. The public should be concerned about whether a nominee can set those aside in favor of following the law. But that's not a challenge just for religious people. I mean, that's a challenge for everyone. And so I think it's a dangerous road to go down to say that only religious people would not be able to separate out moral convictions from their duty.
So in the same way that you just answered, we separate faith from the law. You talked about how we separate politics from the law. So how does that map onto the number of 5-4 decisions in the court, which seem to often break down along partisan lines? Would you say that the court is becoming more politicized?
No, I wouldn't, and that's obviously a popular narrative right now, and it has been at other points in history. As I tell my students when in my former life as a constitutional law professor, I think that those differences are not about partisan politics. I don't know any judges who come to the bench with the aim of saying, I am going to bring into effect the platform of the party with which I was once affiliated. That's not true of those who have been nominated by Democratic presidents, and that's not true of those who have been nominated by Republican presidents. So I don't think that 5-4 decisions or splits on courts are explicable by partisan commitments or by outcomes in particular cases. I think they're explicable by starting points, by first-order commitments. So there are differences in ways that judges approach the enterprise of interpreting the Constitution. I'll give you a couple of examples. All judges think that the original meaning of the Constitution, its history, the way that it was understood by those who ratified it, who drafted it, the founding generation, all judges take that as a data point, as relevant. Those who are committed to originalism treat it as determinative when the original meaning is discernible. Others just treat it as a data point, but one that would not necessarily control. So that will yield different outcomes in different cases. It's the same thing with constitutional text. Some judges take an approach to the text that says, listen, if the text is clear, that's non-negotiable. Others take an approach to the text that treats it as having a little bit more play in the joints. Okay? Some judges approach the Constitution saying there are some constitutional commitments that we're not going to back down from because the Constitution enshrines them. But with respect to those that the Constitution does not speak, we're going to leave it to democratic majorities to work out. Others see the Constitution as having a more amorphous and evolving content and speaking to, evolving values in ways that then democratic majorities don't have the freedom to make choices. So they're just different approaches to constitutional interpretation that will yield different results in many hot-button cases. But that's a lot different than saying, well, it's because such and such a judge goes in and has these particular 5 commitments that are consistent with the Democratic Party platform or the Republican Party platform. So it's really a difference in one's understanding of the Constitution and of the role of a judge.
So you spoke a little bit about the way in which you approach opinion writing, how you separate your personal preferences and take an objective view. When President Obama nominated Justice Sotomayor to the Supreme Court, he famously said that judges should be shaped by empathy as much as by reason, and that, quote, a common touch of compassion, end quote, is a necessary ingredient in a justice or a judge. So do you think empathy or compassion have a role to play? Do they have a role to play in legal reasoning and legal writing?
Well, I think empathy and compassion have a role to play in the life of every human being, right? I mean, we should all be empathetic and we should all be compassionate. And as people, I think that's something that we want to encourage. Do I think it has a role in legal reasoning? I would say no. Well, I would say yes in this respect. I don't think, and I try when I draft opinions to have this in mind, I don't think judges should ever be harsh. So I think you should be compassionate to the losing party who might find it difficult to read the opinion. I'm aware that the party I'm ruling against will read the opinion. And so I want it to be not worded harshly, right? To be phrased in a way that's kind and easy to take. But should the law be driven by compassion or empathy? And I would say the answer to that is no, because that gets mixed up in the judge's personal preferences or feelings. So I think when the law requires a result, sometimes the law requires results that are hard. I think sometimes, the penalties or the sentences that statutes impose for particular crimes, I think this would be something that district judges face all the time when they sentence criminal defendants. Sometimes they don't have a lot of discretion because of the system that the statute sets in terms of how long the sentence must be. And that might be very hard for them to impose that sentence, but if that's what the law requires, you can't have judges saying, that's not what I'm going to do because my heart tells me otherwise. So I think what we want in judges, again, is judges who will follow the law, and we want to be compassionate people. We certainly want to be aware of the effects of our decisions, but I think you get into a dangerous place when you say that you're going to follow your heart and not your head in deciding a case.
You've talked about, at least in conversation with me, about how frequently the Seventh Circuit writes opinions, and you yourself have written quite a few in criminal cases. Mm-hmm. Is that something that it has informed your approach in terms of paying attention to the language that you're using and whether you're coming across as harsh in those opinions?
Sure, I try to be conscious when I write the opinions that the people, who I'm writing that, let's imagine that I'm affirming a conviction or affirming a sentence. If it were my child whose conviction was being affirmed or whose sentence was being affirmed, I would want the opinion written in a very respectful and well-reasoned way and not in a snide way, or to use it as an opportunity to get like some cute lines in or something like that. So yeah, I think it's very important to realize this is serious business, that you're entrusted with heavy responsibility as a judge, and so you should write your opinions accordingly. This is real stuff and people's liberty on the line.
You've had one opinion that drew many opinions that drew attention, one in particular that I'd like to talk about. You wrote a dissent in Cantor versus Barr, which was a Second Amendment case, And in your dissent, you studied founding era documents. Can you talk a little bit about the background of the case for those of us who are unfamiliar with it, and then talk about your approach to those large constitutional questions?
Sure. So Cantor versus Barr was a case in which the defendant, he had been convicted of Medicaid fraud. He had sold shoe inserts that didn't actually comply with the right standards and then been refunded, gotten money for them anyway. It was fraud and he had served his sentence, but under federal law, those who've been convicted of any felony, lose their gun rights, and so they can't possess a gun thereafter. So Cantor argued that he wasn't a threat. This was his only conviction. It wasn't a violent crime. He had discharged his sentence. He didn't use illegal substances. He was stable. He had a job. He was married, and time had passed since this conviction, and he was not a recidivist. So he argued that it was unconstitutional to deprive him of his Second Amendment right to possess a firearm because he did not pose any danger. And the three-judge panel, two of my colleagues, rejected that claim and said that the Second Amendment doesn't preclude, in Cantor's case, there was both a state statute from Wisconsin and then a federal statute that made it illegal for felons to possess guns. So the majority said that that was constitutional, and I wrote a dissent saying that it was unconstitutional. It's unusual at the Court of Appeals level to encounter a case which requires a deep dive into founding era documents, because at the Court of Appeals level, so many of cases have already been decided by the Supreme Court that you're typically applying precedent. You're applying Supreme Court precedent. But the Second Amendment is newer territory. The Supreme Court decided Heller versus United States, Heller versus District of Columbia, not that long ago, and it's only taken one other Second Amendment case since then, so there's just not a lot of precedent out there. So I had to do a pretty deep dive into the history of the Second Amendment, and Heller, the Supreme Court case, is pretty clear about the fact that the scope of the Second Amendment needs to be determined by its history. And I concluded, after surveying all of the arguments, the historically based arguments for the constitutionality of depriving felons of their right to possess firearms, that there was no blanket authorization to just take guns, the right to possess a gun away from someone who had committed a felony. That sounds kind of radical to say felons can have firearms, but I think it's because what the longstanding prohibitions were, and in fact had been even under federal law until more recently, was that violent felons couldn't have firearms. And there's a longstanding, what the history showed me is that there's been a longstanding practice of saying that those who pose a threat of violence to the community cannot have firearms. And that makes sense, right? History is consistent with common sense. Those who would be risky with guns, who would pose danger with guns, then the state can take guns away. But in the instance of someone who the state has not shown that the person has demonstrated any risk, the mere status of having committed a felony, I found no historical support for saying that the state was then justified in taking it away. So, as I said in that opinion, if the state had evidence that Mr. Cantor would have posed some threat of violence if he'd had a gun, then that would be a different situation. But the mere fact that someone had committed a felony wasn't enough. And, overcriminalization gets a lot of talk these days. And when you look at the number of things that are felonies, you can, it's a felony. Now I'm kind of talking off the hip, and I'll see if I can remember exactly which state it was. I think it was Massachusetts. Selling pigs without a license, returning out-of-state bottles for deposits in Michigan can be a felony when it's over a certain amount. And so there's not really a limit on what states can choose to define as felonies. And so it seems a little bit odd to say that the scope of one's Second Amendment right would depend on what a state chooses to define as a felony or not. So I concluded that the line really isn't whether someone is a felon or not, that the line is really whether someone is dangerous or not, that dangerous people shouldn't have guns, but simply saying that someone has committed a felony isn't a good enough reason without markers of dangerousness. But it was hard. I mean, at the Supreme Court, when I clerked, it's even, I think, become truer and truer, you have so many briefs from amici. So friends of the court will file briefs, and they will give you all this historical research, and you have excellent advocates, and so the court has less groundwork of its own to do because the briefing is so rich. And the same is not true at the Court of Appeals. You just don't have all these, amicus briefs coming in. So my law clerks and I had to do a lot of research on our own. So it was a heavy lift.
I bet there's some upcoming law review articles about the research that they did. So if you're looking at founding era documents, would you describe yourself as an originalist? And if so, could you describe your view of originalism, what that means to you?
Yeah, I do consider myself to be an originalist. And my view of originalism, originalists have two basic commitments. One is that the meaning of the law is fixed as of the time that it's ratified, and then that the original meaning of that law controls if it's discernible. So sometimes, laws will have more open-ended, or constitutional provisions even, might use more open-ended language, like the word reasonableness in the Fourth Amendment. Sometimes the language of a constitutional provision is clear, and if the law is clear, an originalist would say that the judge doesn't have the discretion to depart from it. So I do consider myself originalist. And I think, when I was in law school, I think I started gravitating towards that as a first year when I took constitutional criminal procedure, and my professor was not an originalist, but that was my first exposure to constitutional cases. And I didn't go to Hillsdale College, so I had not studied originalism as an undergraduate. So I wasn't familiar when I entered law school with originalism as a theory. But I found myself, as I read more and more cases, becoming more and more convinced that the opinions that I read that took the originalist approach were right. And then as I progressed through my studies and then did more theoretical work, I became even more convinced of that, because that's where the Constitution gets its authority, right? I mean, we agree to live by the Constitution until it's lawfully changed. And judges can't change it. That's not democratic, right? We change it by the prescribed process, which is Article 5. Now, the Constitution doesn't answer every question, and it gives a lot of flexibility. It gives that flexibility to democratic majorities to meet changing times by passing legislation. The Constitution isn't the panacea that cures every societal problem. We have to trust our political branches to do that.
One final question on a personal note. You are a wife, mother of 7, a law professor, and a federal judge. So can women really have it all? And if you had to give advice to young women at Hillsdale and other universities for pursuing a career in the law, what would that look like?
I think each woman is called to a unique path. I don't think there's one cookie-cutter way that women should proceed. And I didn't know exactly what I wanted my life to look like. It kind of became it still is a work in progress. We will celebrate the 100th anniversary of the 19th Amendment next year, which gave women the right to vote. And I think that we should celebrate the ability of women to not only cast their ballots, but to participate in both the private and the public spheres in so many ways that our grandmothers were not able to. So, yes. But one thing I often think when I'll get asked this question a lot, as I think most working mothers do, about balancing career and family. One thing I think that is really important not to lose sight of is that we are so fortunate as women living in 2019 to have so many more doors open to us and so many choices. But I think as part of that conversation, I always want to be careful never to devalue the choices that women make that are different. Women shouldn't have to be cookie cutters. So some women have the flexibility to be able to stay home with children. I have 7 children, and I'm also the oldest of 7 children. And I have 5 sisters. And 3 of us work full-time, 2 of us work part-time, and 1 stays home with her children, and she homeschools them. And she probably works harder than the rest of us. So I think we should celebrate and try to make possible and support and think creatively about ways to provide childcare for women who are in the workplace. And then I think we should also celebrate the choices like my sister Eileen, who is home with her children, and my own mother make to stay home with their children. I just think that one freedom that we should really celebrate as women is that we don't have to just follow a path that seems like the one that people tell us that we have to follow, and we don't just have to think what people tell us that we might have to think as women, that we're really free, and that if you want to live a life that looks a little bit different, I mean, you know, my friend, I have 7 children. 2 of them are adopted from Haiti, and our youngest has Down syndrome. And you know, when my son Benjamin was born and he was in the NICU, my dear friend who I'd known for a long time, was sitting with me. It was a very difficult time. He was on oxygen. She was holding my hand. She looked up at me and she said, "Did you have to be so competitive? You already had the most interesting Christmas card on the mantle." We can make choices to have a life that looks different or odd. I mean, you can be free to be different, and you can stay home with children or you can work, but we should respect the choices that all women make in that regard and the contributions that all women contribute.
Do you have any final closing thoughts?
Gosh, I don't think so. I'm just so grateful that you all came tonight, and it was wonderful to be with you.
Thank you for giving us.
Thank you, Judge, and thank you, Stephanie, for that interview. That was wonderful. I have 2 things for you. One is it's not Notre Dame green, but it's Hillsdale blue.
Thank you. I'll treasure it.
And of course, I do have a last final question for you, which is, what is your position about Hillsdale students as law clerks? And
Send them to me.
Thank you. And thank all those. A lot of people are watching our live streaming, both on campus and elsewhere. I thank them for joining us. Thank you all for joining us, and have a wonderful evening. Thank you very much.
Thank you.